では、はい、Good evening. Thank you for having me today. My name is Sei Shishido from Seikei University in Tokyo. I am delighted to be here to discuss the main developments in Japanese competition law and policy during 2025. Right. Okay. So let me start with a brief overview of how 2025 fits into the broader trajectory of Japanese competition law. The year 2024 was a legislative year for Japanese competition law. Two critical pieces of legislation were enacted: the Freelance Act and the Act on Promotion of Competition for Specified Smartphone Software. I'm going to call it just new smartphone software. These laws represented significant reforms aimed at protecting gig workers and promoting fair competition in digital markets. 2025, by contrast, became a year of implementation and preparation for those legislations. In enforcement of the Anti-Monopoly Act, there was significant intervention in digital markets, most notably the cease and desist order against Google. The JFTC also published comprehensive guidelines and case studies in new policy areas such as economic security, creator support, and green society realizations. Next slide. Let me begin by discussing the implementation of the Freelance Act, which was enacted in 2024 to protect gig workers and independent contractors. In March 2025, the JFTC conducted its first enforcement action under the Act. The JFTC conducted intensive investigations of business operators in game software, animation production, relaxation services, and fitness club industries. The result was advice. I don't know if it's right way to say because it's in Japanese. 指導 I don't even know if it's 行政指導 or just a 指導。ありがとうございます。Thank you, Waki Sensei. So the result was advice by JFTC issued to 45 business operators regarding corrections to contract documentation, like order methods and payment dates. These guidance actions were based on Article 22 of the Freelance Act and represented the first concrete enforcement case under the new legislation. Next. Regarding the new smartphone law, the designation of specified software providers was made on March 2025. However, as the law was only recently enacted, no specific enforcement cases had yet emerged as of 2025. It is worth noting that this law represents a significant shift in Japan's approach to digital regulation. Regulation in digital market. Rather than relying solely on the Anti-Monopoly Act, Japan has enacted a sector-specific law to address this issue in smartphone markets. And then next. Before we move to the cases, let me mention one important administrative development, the Subcontract Act. The Subcontract Act has undergone a rebranding effort, discontinuing the use of the term subcontractor, shitauke, and replacing it with the term small and medium-sized entrusted business operators to communicate the regulatory purpose more clearly. From January 1st, 2026, the title of the act will also be changed to Act Against Delay in Payment of Fees, etc., to small and medium-sized entrusted business operators in manufacturing and other specified fields. aka the Act on Proper Transactions with Small and Medium-Sized and Trusted Business Operators. This reblending reflects a shift in regulatory framing from a focus on the relationship between parties to a focus on the protection and promotion of fair or proper transactions. Next. Now, let me turn to the cases in 2025. I will organize my discussion around four categories of conduct. First is exclusionary conduct by single firms. Second is concerted actions, including cartels and bid rigging. And third is vertical restraints. And the last one is abuse of superior bargaining position. I will then discuss merger reviews and finally the GFTC's guidelines and case studies regarding economic securities and the other things. Let me begin with exclusionary conduct by single firms. The most significant case in 2025 was the cease and desist order issued against Google on April, I guess, this year. This case addressed exclusionary conduct by a dominant firm in the market for general search services. Google imposed multiple conditions on Android smartphone manufacturers when licensing the Google Play Store app or sharing its revenue from the general search services. Through these conditional agreements, Google prevented certain Android smartphone manufacturers and certain mobile carriers from implementing search functionality from competing general search service providers on their devices. The specific conditions Google imposed were quite extensive. Under the licensing agreement, Google required manufacturers to pre-install the Google Search app and position its widget on the initial home screen, and to pre-install Google Chrome and set it as a default browser. Under the revenue distribution agreement, Google prohibited manufacturers from implementing competing search functionality or even allowing third parties to introduce competing search providers to use. The JFTC determined that this conduct constituted trading on restrictive terms under Article 19 and General Designation Item 12 of the Anti-Monopoly Act. Through Google's conduct, competing search providers' opportunity to have their search functionality implemented on Android smartphones were restricted, thereby restraining competition in the general search service market. This case is substantially parallel to US cases, though there are important differences. Japan's cease and desist order does not address remedy design considerations such as those arising from developments in generative AI. Instead, it simply prohibits the imposition of MADA and RSA. There is also an important case in the medical testing equipment market. The commitment plan submitted by Sysmex Corporation on February 2025 addressed the competitive restraint conduct in this market. But I think I don't have enough time, so I'm going to skip the detail of the case. But I'm just going to mention that in this case, the JFTC determined that the conduct by Sysmex was violated the Article 19 because it is tying, according to the General Designation Item 10 of the Anti-Monopoly Act. However, no violation was found, and the matter was resolved through the commitment procedure. The commitment plan submitted by Sysmex ensure that when supplying specified blood coagulation measurement devices, other manufacturers' reagents could be used, and the opportunities for transactions between competing reagent manufacturers and medical institutions would be preserved. This case is interesting because it demonstrates that the GFT's willingness to use the commitment procedure to address competitive restraint effects while promoting voluntary improvement by enterprises. And the other tying case was the Toyota mobility case. Toyota Mobility Tokyo received a caution on April 2025 for tying in connection with the sale of specified Toyota vehicles. The company required customers to purchase body coating services, maintenance packages, and financing services sold by Toyota Mobility as a condition of purchasing vehicles. This case demonstrates, okay, I'm going to skip. Now let me turn to concerted conducts. While last year saw frequent references to a high number of bid riggings and cartel cases, the situation continued in 2025, in my opinion. In fact, bid rigging cases, I can see bid rigging cases across multiple industries. So in general, the cease and desist order against manufacturers of special purpose vehicles and trailers on September addressed the conduct where multiple manufacturers predetermine the successful bidder in public and private construction project biddings and discouraged other bidding participants from submitting bids. The GFTC determined this conduct constituted an unreasonable restraint of trade under Article 2.6. Similar bid rigging was confirmed in other industries. The cease and desist order against mechanical parking system manufacturers on March addressed conduct where multiple manufacturers predetermined the successful bidder in biddings for parking system installation. These cases demonstrate, okay, well, I need to skip. Next, slide 13, okay. And the case of Yamagata Livestock Association. A particularly interesting case is the bid rigging case involving, I can't read it. That's a vaccine for pigs and other animals in biddings issued by Yamagata Livestock Association in March. There are three companies, Agro Japan, Odashima Shoji, and MP Agro, agreed to prevent price declines in biddings by predetermining the successful bidder and agreeing that unsuccessful bidders would cooperate to ensure the predetermined successful bidder could win the bid. And the other case is regarding Tokyo Olympics. The cease and desist order against companies involved in Tokyo Olympic and Paralympic related projects on June 23 addressed bid rigging in large-scale public construction projects. And I'm going to skip. And let me now turn to vertical restraints, which include resale price maintenance, territorial or customer restrictions, and restrictions on sales methods. The GFTC addressed the resale price maintenance through both cautions and commitment plans. Kyushu Shishi received a caution on March for conduct where it maintained resale price to retailers. Dunlop Tire's commitment plan was approved on August for resale price maintenance of synchro weather tires. That's a specific tire for specific weathers. This case is okay. I'm gonna skip to the next slide. A more complex case involves vertical restraints by a payment network provider. I think this case is very important. The commitment plan submitted by Visa on July addressed vertical restraints by Visa in payment networks. Although Visa held a dominant position in payment networks, it provided discounts to merchants when they used Visa's own payment services, thereby restricting the use of competing payment services. Specifically, by providing discounts when merchants used Visa's payment services, Visa substantially restricted the use of competing payment services. The GFTC examined whether this conduct potentially constituted a trading on restricted terms under Article 19, Item 12, and accepted the commitment plan submitted by Visa. And this case is also notable. The caution issued to live streamer agencies on December. It's just released, represents an important case of vertical restraints in emerging industries. 4 live streamer agency operators included provisions in management contracts that, for the purpose of deterring live streamers from switching to other agencies or becoming independent, prohibited live streaming activities for a specified period after contract termination, prohibited entering into management contracts with other live streamer agencies, and prohibited engaging in similar business activities. The GFTC issued a caution under Article 19 and Item 12 as a trading on restricted terms, or Item 14, interference with competitors' transaction of the Japanese Anti-Monopoly Act, as potentially violating these provisions. This case involves conduct by live streamer agencies through management contracts that restricts the business activities of live streamers, creating effects such as making it difficult for competing live streamer agencies to easily acquire more popular live streamers, and making it difficult for live streamers to establish new live streamer agencies after contract termination. Now let me turn to abuse of superior bargaining position, which is particularly important and distinctive feature of Japanese competition law. But I just learned that Taiwan also has the same kind of regulation. The regulation of abuse of superior bargaining position in Japan's Anti-Monopoly Act is often understood as a special rule in light of fundamental principles of competition law. This regulation addresses a situation where an imbalance of market power exists, focusing on conduct by a firm in a superior bargaining position that uses the position to impede the independent and free decision-making of its trading parties. In other words, this regulation aims to restore the foundation of competition by regulating conduct that restricts the independent and free decision-making of trading partners in situations where a foundation of free competition does not exist. This is a distinctive approach that reflects Japan's particular concerns about fair transaction, proper transaction in supply chains and distribution networks. The most significant case in this category in 2025 was against Harley-Davidson Japan, which resulted in both a cease and desist order and surcharge payment order. This case involved Harley-Davidson Japan imposing a reasonable annual retail sales target uh, on certain dealers and forcing them to comply. The JFTC found this violated Article 19 and Article 2.9.5 as a abuse of superior bargaining position. The specific violations were quite detailed. Uh, Before presenting the agreement to specified dealers, Harley Japan did not consult with them regarding the target number of proposals and did not provide them with an opportunity to express their views. After presenting the agreement and before dealers submitted the signed agreement, Harley did not adequately explain the basis for calculating the target number proposal, and even when dealers expressed views or requested downward revision, they didn't. They rarely consulted with them and did not downwardly revise the proposal. Furthermore, when dealers' target number achievement rate fell below a certain percentage, the possibility existed that the dealer agreement would not be renewed, and that's a termination of the contract. Under these circumstances, Harley made a strong request by telephone and other means to dealers to increase their target number achievement rates and had them create improvement plans and promise implementation at meetings. And the other case is the commitment plan submitted by Nishimuta on September addressed abuse of superior bargaining position in the retail industry. Nishimuta held the superior bargaining position over his trading partners and used that position to impose unfair trading conditions on them. The JFTC examined whether this conduct potentially constituted abuse of superior bargaining position under Article 2.9.5 and accepted the commitment plan submitted by Nishimuta. The commitment plan included the elimination of unfair trading conditions imposed on trading partners, the establishment of fair trading practices, and the construction of a mechanism for consultation with trading partners. And I think I should skip these two cases. Atore case. Atore is the famous shopping mall integrated to the Japanese train stations. And Shinmei Benzai case. I think I'm going to skip this one too. And okay, let's move on to slide 23. The JFTC issued a large-scale caution to 646 shippers on June regarding abuse of superior bargaining position in the logistic industries. The caution identified 7 types of problematic conduct, including unreasonable demands for price reductions, unreasonable demands for service improvements, and other conduct that restricts the independent decision-making of logistics service providers. Next slide. Under the Subcontract Act, which will be renamed next year, the JFTC issued guidance on December 23, just a few days ago, directing 530 companies to cease unfair trading practices. The guidance addressed the specific practices that violate the Subcontract Act, including unreasonable demand for price reductions and unreasonable demand for service improvements. This reflects the agency's focus on protecting suppliers in supply chain. And the JFTC issued guidelines on price transfer for labor costs on March 25. The guideline addressed how companies should transfer labor costs increases to their trading partners. A survey showed that 59.6% of companies were aware of the need to transfer labor cost increases to their trading partners, indicating that the importance of the guidelines in promoting fair supply chain practices. And business combination, which is merger review, remained a central function of the JFTC in 2025. Among the largest cases was the integration of Imabari Shipbuilding and Imabari Zosen and Japan Marine United in the shipbuilding industry on November. On November, the JFTC conditionally approved this integration. The integration of Imabari Shipbuilding, Japan's largest shipbuilder, and Japan Marine United, its second largest competitor, had the potential to increase competitive concern in the large vessel construction market. In this case, concerns arose that group companies of the merging parties, specifically downstream engine manufacturers, could obtain conditional information. The JFTC approved the integration on the condition that multiple measures would be implemented to prevent such access to conditional information. Okay. On March 27, the JFTC approved Kubota's acquisition of shares 19.9% in a newly established manufacturing subsidiary of Nippon Cast Iron Pipe, subject to remedies. This case represents an important example of the first actual application. I don't know if I should call it actual application, but they referred to the green guidelines in an actual merger case. The competitive concern in this case was that the combined market share of the merging parties in the ductile iron pipe market was approximately 70%, which was high. And however, the JFTC decided to approve based on efficiency evaluation. Let me explain the efficiency evaluation in detail. Through the newly established manufacturing subsidiary, Kubota and Nippon Cast Iron Pipe would jointly manufacture small diameter ductile iron pipes, enabling a switch from cupola furnaces to electric furnaces. This switch would result in a substantial reduction in carbon dioxide emissions. Importantly, through the formation of a capital relationship, Kubota could provide know-how regarding electric furnace operation. Since Nippon Cast Iron Pipe lacks experience with electric furnace operation, this know-how transfer would be beneficial for early realization of electric furnaces. A mere business partnership would lack a capital relationship, making know-how transfer difficult and preventing achievement of equivalent efficiencies. Therefore, efficiencies specific to this conduct were recognized. Under the green guidelines, substantial reduction in carbon dioxide emissions in the manufacturing process of small diameter ductile iron pipes can be evaluated as improvement in quality. This evaluation is important rather than being recognized merely as an environmental effect. The improvement in the product quality provided to consumer was recognized, thereby establishing an increase in consumer welfare. The green guidelines specify that activities toward realization of a green society have competition promoting effects, and that products contributing to reduction of greenhouse gases emission in production stages are included in the superior products. This case represents the first case in which these provisions were concretely applied. I mean, they actually referred in an actual actual merger case. And in 2025, the GFTC published comprehensive guidelines and case studies addressing complex policy areas and regulatory issues. These publications provided information regarding the GFTC's enforcement approach in specific areas and improved business predictability. First one is regarding economic security. I think I'm going to skip the detail, but I would like to mention that the main content of this document presented the GFTC's approach under Anti-Monopoly Act to hypothetical cases presented by the Ministry of Economy, Trade and Industry, and the Ministry of Land, Infrastructure, Transport and Tourism. The GFTC suggested the compatibility of economic security and competition law and provided specific guidance aimed at improving business predictability. In particular, when business engage in cooperative conduct out of national security necessity, they can now determine in advance whether such conduct would violate the Anti-Monopoly Act. However, from a competition policy perspective, there is a point requiring attention between economic security and competition law. There exists a potential conflict structure between industrial policy and competition policy regarding which products and services to include as target of economic security. From a competition policy perspective, it is necessary to monitor that the scope of non-application of the Anti-Monopoly Act is not carelessly expanded under the guise of economic security. While the GFTC document suggests compatibility of economic security and the competition law, the delineation between industrial policy and competition law may become a future issue. On September 30, 2025, the GFTC published guidelines regarding fair transactions between performers and talent agencies, broadcasters, and record companies, and released a fact-finding report on transaction fairness for creator support. This document targeted the music industry, broadcasting industry, and entertainment industry. I think I don't have a time, so I'm going to skip the detail. And there are some other guidelines also. And let me now summarize the key developments in Japanese competition law and policy during 2025. First, 2025 was a year of implementation of the legislative reforms enacted in 2024. The Freelance Act was actively enforced so far, with 45 business operators receiving advice, Shido, in the first enforcement action. The new smartphone law was enacted but no specific enforcement cases had yet emerged. And about vertical restraints, increased focus on digital and platform markets and distribution restrictions. And abuse of superior bargaining position, high-profile enforcement like Harley case and industry-wide actions like the one regarding logistics to protect smaller trading partners. Additionally, in the digital domain, the largest case was the cease and desist order against Google, as I mentioned. As a new smartphone law is implemented, there are various discussions about how digital markets will change through GFTC's intervention. Some opinions suggest that deficiencies in deficiencies in the cease and desist order this May, will be supplemented by the new smartphone law, which is I think which is interesting to monitor in the future. And in the last slide, the JSTC published guidelines and fact-finding reports on economic security, creator support, the logistic industry, and the generic pharmaceutical industry within this year alone. For an organization of approximately 1,000 people, less than 1,000 people, I guess, it is fair to say that very active work is being conducted. Thank you for your attention. I would be happy to take any questions.